Gucci!
Are you about to dismiss this?
No.
Okay, then set the court date and I'm leaving.
Is that a trial date?
Yep.
What's the trial date?
I want to be heard on 2 matters.
You guys can talk amongst yourself when I'm gone. Because if you start the hearsay bullshit again, you're a tainted jury. So if he says anything other than anything about the case, you just tainted the jury. Because if the jury was sitting here, he wouldn't be able to talk hearsay.
You don't get a jury trial, Mr. Mayor.
I don't what?
You don't get a jury trial.
You're the jury. You're supposed to be an impartial judge, which means an impartial jury. If you let this man spout off about anything other than the facts of the case, you just tainted the jury, You'll be recused like the last 4 judges. You'll have a Commission of Judicial Conduct complaint. You'll have a lawsuit. You can laugh and joke all we want. This is an unethical piece of shit prosecutor.
Oh, do we have an update for you, YouTube, on Lane Myers. Lane Myers is a pro se litigant that we've covered in a couple of our videos. He's represented himself in a number of cases, and he's won. Pretty impressive. Equally as impressive, and some would say shocking, is how Lane litigates in open court.
You cannot object to this. People can walk in and say, Your Honor, I'm recording, set it down, it's on my person, I can broadcast, because the word broadcast and the word cover and coverage are defined in the Supreme Court order, so we avoid stupid ass conversations like this.
Mr. Myers, again, and we raise our voice, why?
Because she doesn't hear well.
Right.
He's a passionate guy. On a more serious note, Lane is currently being held without bond in the Pima County Jail and is facing 45 years to life in prison.
The clips you're about to see are the best of Lane Myers representing himself in open court. And along the way, we're going to explain why Lane is currently being held without bond, facing up to the rest of his life in prison.
I'm not threatening shit. I'm threatening to file a formal complaint on you because you're a piece of shit.
Fine, sir.
You're a fucking scam-ass judge over creating some bullshit.
Sir,
This is straight bullshit, and that's a lying sack of shit right there. Fake witness, wannabe victim.
Sit down. Thank you.
Play games. Put this clown on the stand.
Quiet, please.
Why the
Sir.
is this a pretrial?
Yes, it is.
Then why the are there witnesses here if I can't bring mine?
No one said you couldn't.
The fucking law says it, motherfucker. The fucking rules of procedure said at the fucking pretrial you can't bring witnesses. So why the fuck is she here? Because the state's a fucking unethical piece of shit manipulating this fucking court system because Romero's your fucking boss. Delorier's a dumbass. Where the fuck is the arresting officer? Why is this bitch here not the fucking arresting officer?
Sir, calm your language.
Why couldn't I bring the fucking witnesses?
Sir, please.
Where's my witnesses?
This is a pretrial conference.
Then why the fuck are there witnesses
They're
here?
allowed to be.
They're not.
Yes, they are.
No, they're not. Read the fucking rules, bro.
Are they the victim?
They're not the fucking victim, and if he pulls that shit, you're getting recused too.
Sit down. Are they the victim?
No.
I'm asking.
I got the fucking police report right here.
Are they the victims?
If you fucking lie, you already know what fucking time it is.
One of them is the victim.
Who's the victim? Neither one of them is a fucking victim. A victim of her own fucking stupidity, maybe. She's a sir.
Sir.
Judge Riolas, that woman is listed in the police report as a witness, okay? This piece of shit hasn't turned over his fucking witness list, and it's been 105 days. Where's the Rule 15 witness list? How the fuck are we gonna have trial if I haven't even received the witness list yet? Huh, Rojas? We have fucking 30, 40 fucking days to have the trial, and I haven't even received... What? He's gonna call her as a witness? Why hasn't he disclosed that under Rule 15 2B, 1.1B? Where's my fucking witness list? Where's the state's disclosure? It was due fucking July 11th. Then Crenshaw said August 9th. Then Mayhew lost her fucking mind and didn't enforce it. Anything that this motherfucker didn't file by August 9th is not valid at trial. So if he didn't turn over a witness list by August 9th, there's no witnesses. And if you try to enforce some kangaroo bullshit, you'll be right up there with Crenshaw and Mayhew, right where the fuck they went. Time out.
Done?
There's nothing more to say. Set the trial date so I can leave so I can quit disrupting your court.
Sit down.
You let this motherfucker get off some bullshit, it's gonna be on you.
Fine.
The court must state specific reasons for continuing trial. Not just put a thing that says your trial's vacated, it's continued, that's not a specific reason. And when I fucking object to it, and she says, oh, you can't put the word bullshit in your order, so I'm objecting to it, or I'm striking it from the record. So my objection to my trial being vacated didn't get put out, whatever you want to, litigated motion between us because she struck it from the record because my motion had the word bullshit. I've said fuck 50 times already today. Why did my motion get struck for bullshit? That's why she was my judge for 3 days. This piece of shit stands at the thing.
Sir. All
right, I'll stop. All right. I'll talk to you. So this unethical prosecutor stood in Judge Mayhew's courtroom after I got kicked out and literally talked into this microphone and said, Your Honor, I'd like to be heard for the record. We're getting the times, dates and times available for our witnesses. We'll let you know when you have trial. So how the fuck does he know his names and times of witnesses, but I haven't even received it? I'm the fucking defendant, and it's been 100 days. So he's telling the court, I have my list of witnesses, and I'm saying, yeah, it was due 3 fucking months ago. So how does he have his list of witnesses? He's telling the court he has his list of witnesses, but the defendant doesn't have the list of witnesses. How can I prepare my trial? How can I interview this moron if you fucking don't give me their name and their information as required under by law, right? So, Rule 15.1b, the state has 30 days from request. I put in a motion to compel, fucking law 4 fucking months ago. They had 30 days from that motion to give me their 15.1 disclosure, witness list, all that shit. Or by the first pretrial. That's the law, sir. You follow the law. The law said first pretrial, you must receive. I've turned over all my disclosure. They've had all my Rule 15 disclosure, all my witnesses, all my evidence, everything for 4 fucking months. I don't even have the witness list. But they're openly admitting on record that they've been interviewing witnesses, talking to witnesses to get their time available for trial. They're clearly communicating, but I don't have a witness list. How can I prepare? How do I know who's gonna be called against me? Due fucking process. And I'm telling you right now, I got a federal lawsuit in a different county about judges that let this kangaroo bullshit done. And I'm telling you, you can read my lips. He will be under 2-year buyer suspension. Play games, and it's gonna be you caught in the middle, sir. And it's not, and I'm not, this is how I gotta talk, because this is my 5th fucking court date where nothing's happened by the law. So either today it's gonna go by the law and you're gonna dismiss this shit under Rule 8 and Rule 15 because my right, with prejudice, speedy trial rights, they have nothing. So how are we gonna have a trial if they have no admissible evidence because they didn't turn it over by August 9th?
First of all, sir, can't dismiss the case once you filed the motion.
I have, and they fucking threw it out for the word bullshit. That's fucking bullshit itself.
Have a seat, please.
First thing the state's going to ask for is a motion to modify the conditions of release. All these requests are going to be directly stemming from the case. They're not going to impact Mr. Myers' ability to defend the case in any way. Mr. Myers has taken the information the state has provided under Rule 15 and posted on the internet. That's a violation of Rule 15.4.
Oh, sir, objection. We're not fucking having.
Sir, he didn't interrupt you. You don't interrupt him.
You better fucking hold the law.
Sit down.
A violation's a violation.
I said sit down. You'll have a chance.
He don't get to stand over there and cry victim.
Sir,
He's the fucking state of Arizona and the burden of proof's on him.
Right.
Give me the fucking witness list. You want to sit over there and talk shit about what I violated?
Sir.
Guess what? I didn't post shit until he violated the August 9th rule.
Sir.
So if you don't follow the rules, you don't get to enforce them.
Sir, you're toying dangerously.
I get it. I feel you, sir. I feel you, sir. It's nothing personal. It's nothing personal. It's nothing personal. It's nothing personal. It's fucking business, man. It's business. This is my 4th judge. This is 106 days. 106 days into the case. You only have 180.
Included time. When you file a motion, continue.
I did not file. This is the bullshit, sir. There's no fucking motion filed by me to continue, and that's the bullshit Cranshaw tried to pull. The last judge tried to pull. I did not file a fucking motion to continue anything. I filed one before my 11th pretrial. I then withdrew that motion. It was ruled on, withdrew. I showed up at the fucking hearing. Cranshaw wrote that shit on there. I filed a motion showing that wasn't true. They didn't fucking hear it because it said bullshit. You better not, sir. You better not come in here and state into that fucking microphone that I filed something to continue my trial. That will be the misconduct commission complaint that you can't fucking read.
The district attorney in that case was Matthew Walker, and he was the one pursuing charges against Lane. That case all stemmed from an argument between Lane and an O'Reilly's auto parts store clerk that got blown way out of proportion, based on lies told by one of the cashiers. Now, you're going to hear Lane repeatedly confront that district attorney, Matthew Walker, in his unethical practices during this case. Just watch.
Back to what I was saying, under 15.4D, none of this material is supposed to be disseminated.
He's talking about the police report and the body cam. See how he's saying material? Police reports and body cam.
He didn't interrupt you.
Police reports and body cam.
Common courtesy.
Police reports.
I'll let him interrupt
Thank you. Thank you.
And you will not interrupt him.
Thank you.
Go on.
The material that's provided under Rule 15, like the body-worn camera and the police reports, is not to be made public. So on that basis, Mr. Myers has violated Rule 15. The videos need to be removed from YouTube, number one.
They're not coming down.
Number two,
Ever.
if they don't come down, the state is going to ask the court that you hold him in contempt.
And I'll do it. Pay, how much do I owe? The videos are not coming down, sir, ever.
Second thing is...
It's my First Amendment right. And no, hold on. Objection. I know. Let me peacefully, all right. Let me peacefully, I have an objection to what he just said. Let me peacefully make my objection, sir.
Please, can we move on?
He just said that, hold on, time out. No, sir, I have the opportunity to be heard.
You did what he's done.
No.
When he's done.
Directly to what he just said. I'm objecting what he just said. I want to put an objection on the record to the first thing he just said. Okay. He said that I was releasing body cams and and body-worn camera and police reports that they provided. That's wrong. I got it from a public record request from Kris, city attorney. So anything I get from a public record request, I can put on my YouTube channel. Now it might be the same material that's in their disclosure, but we could go to court. Charge me with contempt. I'll show you the public record request. You can see a video on my YouTube of me giving the public record request to Kris Avery, and Kris Avery going, here, take a picture of me. Kris Avery stands on my thing and goes, look, I got your public record request. So he's lying again. He's lying. He just said I should be held in contempt for releasing a public record received under a public records request. He's lying. He's attempting to manipulate because I sound crazy and all that. He's trying to be the voice of reason. He's the voice of lies.
During this hearing, DA Matthew Walker makes multiple arguments where he manipulates the truth, and at some points, just outright lies. But notice, at multiple points when Lane asks him to present the evidence to put on the record, DA Walker all of a sudden gets quiet, or just moves on to the next argument.
He gets to tell you what you need to do.
He's asking. You tell me. He's asking.
I'm requesting to modify Mr. Myers' conditions of release accordingly. Number two, Mr. Myers needs to be directed not to have any direct contact with judges, court staff, city prosecutor staff, or other city employees. If he wants to do something on a case, he can file a motion through the appropriate
He just asked you, objection.
Sit down.
Objection, public officials. I can contact public officials at any time. Every person he just said is a public employee. You will not take away my rights. Every person he said, though, was public record, public official.
Go on.
And these are people that Mr. Myers has been harassing and calling cunts, among other things, Your Honor.
Objection, irrelevant, man. What the fuck does that got to do with what I did on May 20th? Who I called a cunt? He's taint. That's irrelevant. You're allowing him to prejudice the jury, sir. You're supposed to be impartial. That means that if the jury was sitting here, you wouldn't allow him to say that I called it a public employee a cunt. That has nothing to do with this case. So you have to act the same as if the jury was sitting there, sir. That's how you have to be at all times, an impartial jury.
Let me ask you this question. How do I know what he's going to say until he says it?
Who? Ahead of time.
How would I know ahead of time?
Ahead of time what he's going to say.
How would I know ahead of time he's going to say what he's going to say?
Well, now that he said it, why didn't you say that's irrelevant? Why didn't you say that has nothing to do with his guilt or innocence on May 20th? Then why the fuck? That's the third case courtroom I've been in where he talked about me calling him cunts. Hey, cunt is free speech. Whatever. So,
but it's not polite speech.
I don't care if it's polite.
In this courtroom, you be acting.
I understand. Don't call nobody in here. But I'm saying, he's saying that in my communications with public officials, I've called them that, right? That word, right? Mm-hmm. That's my right, okay? And it has nothing to do with whether I'm guilty or innocent with what happened at O'Reilly Auto Parts on May 20th.
I agree.
So why is he, do you understand? Why is he talking about it?
Quiet. Let him finish. Go on.
Your Honor, the court can impose modified conditions of release for the protection of anyone in the community, and of course, have wide discretion to do that. It is not onerous to ask Mr. Myers not to call court staff or not public officials.
Take away my rights is onerous.
Number three.
You're a bro. Your wife's a
Sir.
Your Honor, I'd ask Mr. Myers to be held in contempt.
I'll pay the fine. You're a your wife's a How much is the fine?
I'll book you.
Well, you think jail? So now you definitely are removed from the case because you just threatened me with jail, just like Cranshaw did. And look what happened when Cranshaw threatened to throw me in jail.
Number three.
Put me in jail for saying it. I dare you.
The state will respond to any substantive motion filed that is not stricken by the court.
How can my motion be suspended? Here's my motion. Permission to approach. Here's my motion. Permission to approach, sir.
Please finish your.
Let him finish. You have a chance to say when he's done. Go on.
No contact with non-court prosecutor, people who are not related to this case, such as immediate family.
His wife's a public official. His wife is a public employee. Don't let him gaslight us.
So now that clip is super important on what's going on with Lane's case right now. Notice how Matthew Walker brought up his wife. Her name is Shannon Walker. She is a public employee by definition. She's a director of one of the programs at the University of Arizona Law School, and her position at the university specifically mentions public outreach work. During the O'Reilly's case, Lane would end up leaving a voicemail on Shannon's work voicemail, which as a public employee, Lane is allowed to do under the First Amendment. Now, this voicemail would cause Shannon to go in front of a judge and allegedly lie to obtain an injunction for harassment against Lane, which she was successful in doing. And this sets the groundwork for why Lane is currently being held in jail without bond.
Like the voicemail Mr. Myers left for my wife saying he...
Yeah, and I'm gonna keep sending her fucking emails and calling her because she's a public official.
And the email that he sent to me saying he was gonna come pay my wife a visit and then come...
Now he's lying. Here, sir, I'm gonna show you permission to approach. I got the email right here. I said I'm gonna go knock on his neighbor's doors and ask him if they wanna vote for Trump. That's what I said. So he's twisting the narrative. He's a squeamy little bitch. I'm telling you, man. I'm telling you, dude, you're letting this fucking prosecutor embarrass the entire profession. You and this prosecutor are embarrassing the entire legal profession right now. Unless you're about to dismiss this for all his games. He can't make a serious argument. Oh, the police said this. This is what happened. Nothing. It's, oh, he called him a... Oh, he emailed my wife, who's a public official. Oh, he said he's gonna come put a billboard sign for Trump and next to my neighbor. I didn't say I'm coming to his house. I said I'm gonna go to his neighbor's house. It's fucking public record. He's a public official. It's public record. You can type Matt Walker in Google. You'll know exactly where he lives. He's a public official. He has a less expectation of privacy than a private citizen. I've checked all the laws for residential picketing. I'm not breaking the law, so why is he bringing it up? I'm hurting his feelings. Fuck his wife. She's a public official, whatever. I can talk to public officials as long as I don't threaten them. I can go. I went and stood in front of Laura Conover's house. She didn't tell the fucking judge, oh, he came in front of my house. He called me. I call Laura Conover every day. Why can't you just stand on business, bro? You've been here 20 some years, dude. I know we both know whose interests you're protecting, but I'm not accusing you of impropriety yet. But if you just told me I would go to jail for saying protected speech, yeah, you could say it. But you actually have to have a trial for contempt. And you can't issue contempt in the same hearing that the contempt takes. So like, you just literally threatened to put me in jail, knowing that you can't even do nothing about my contempt. You have to issue an order to show cause for contempt. So how the fuck are you gonna put me, you know what I'm saying? So you just attempted to manipulate your power against me by saying, I'll lock you up. You can't, you can show it, or now you can issue order to show cause, sure. And then we can have a hearing about my contempt. And then if I'm found to be in contempt, if it's criminal contempt and you wanna try fine over $300, criminal contempt doesn't carry jail. It's a civil infraction. It's not a crime. You can't be taken to jail for contempt. You can be detained while a show cause order is issued. You are not gonna weaponize the court either, sir. He's not gonna, and you're not gonna.
Any further, Mr. Walker?
Sure, Your Honor. These conditions that the state is requesting have absolutely no bearing on Mr. Myers' ability to defend the case. They have no bearing on his ability to do anything. The state would like nothing more than to simply proceed with this case without Mr.
Then why don't they give me the fucking witness list? It's 105 days. They want to proceed with the case? Give me the fucking witness list. Give me the arresting officer. You can't proceed with the case? They're sitting here saying, oh, he put the videos up. You heard our feelings. You said you were going to protest in front of my house. My legal right. You're going to exercise your legal rights while we violate your rights and hold the witness list and hold all this. He wants to modify the conditions so I can't contact public officials. Oh, he's got the public records up on there. But he hasn't turned over anything. Every single fucking piece of disclosure under Rule 15 that I'm required to give, I've given. They've given none. None. None.
File a motion.
I did file fucking 10 motions and she lost her shit, just like you're doing it, bro. I'm telling you, I can see. Next time, objection. So you made your witness list.
Mr. Myers, sit down.
Tell him to,
Sit down. You have a chance
tell him to state for the record. Where's the witness list?
You'll have a chance to respond.
If he's made the witness.
You'll have a chance to respond when he's done. Okay? I'm not preventing you to speak. Just have kind of be orderly here.
Now you can hear the main argument in this hearing was that DA Matthew Walker didn't release the witness list to Lane even after he was ordered to by a judge. And he did this for a couple reasons. One being so that Lane couldn't prepare for his case. And the second reason being so that Lane couldn't depose his arresting officer in this case. Because Matt Walker knew that Lane was going to confront the officer on his lies. Thankfully for Lane, he got an ethical judge in this case, Judge Riojas, and he could clearly see what was going on here.
Okay, Your Honor, can we move on?
No, we can't.
Can we move on, please, Your Honor? Thank you. Okay.
Why does he want to move on?
There's no chance that an interview is going to be productive with Mr. Myers.
No chance.
Police officers.
No chance.
I think it's better to just do an evidentiary.
He thinks that my rights should be violated. I should take away my right of free speech.
Can you please exercise some control here and please stop?
Can you exercise some control and stop lying?
Mr. Myers, sit down.
This judge is doing a great job of handling this. You're the one that's standing here lying and inflaming the situation with every lie.
Mr. Myers?
Every time he lies, I get mad, right? It's pretty obvious. Every time he lies, I get mad. Every time he doesn't lie, I don't get mad. I got it. I'm in control. Trust me, I'm controlling myself. You know what I'm saying?
If the court wants to order a deposition of the officers under Rule 15.3, that's within the court's prerogative. I think an evidentiary would be best.
Well, I already filed the motion for that, but they won't rule on my motion to produce the officer. I filed it months ago. Okay, I'm following the procedures. I filed the Rule 15 motion because I tried for weeks and months to get the interview. Then I filed the motion to compel the interview. And this man hasn't responded to one of my filings in months. Months. How can we litigate? If I was a defense attorney, the state wouldn't ignore him. It's because it's me, and they know what's gonna happen. If the interview's so bad, it's gonna make me look bad, right? So if giving me a pretrial interview is unproductive, well, the state should want that then, because we're gonna have the interview, and it's gonna make me look bad. So if I'm the problem with the interview, then let's schedule the interview, and if I go off, if I'm disorderly, or you know what I mean? If I violate any rules during the interview, or you get what I'm saying? Then just end the interview. So why am I not given a chance to get a pretrial interview, follow the rules of pretrial interview, and then you can decide? You're prejudging me. That's the definition of prejudice. This is a tactical advantage. They don't want me to interview the cop because I'm going to get to prepare for trial, and then when I got him under oath at trial, I'm going to get to hit him with all his lies, and then I'm going to perjure him, but instead they want to hide the cop till trial. You've been here 25 years. They want to hide the cop at trial. I smell shit, right? I smell poop. You've been here, bro. You know how the game works.
Okay. I'll go ahead and order a deposition.
Thank you.
I'll ask you first, and then I'll ask you, okay?
Again, Your Honor, I don't think abusive, profane language, I don't think being able to go in there and accuse the officers of sexual conduct with people on the case is going to be an appropriate topic for a deposition. So what conditions is the court attaching?
It's too hard for me to predict.
Thank you, sir.
I can't, at this point in time.
It's up to me if
Until it does something, I can't.
It's kind of like pornography. You know it when you see it. You know what I mean?
So what I'm going to order is a deposition.
So every little trick that DA Matthew Walker tried to pull in this case, he got denied. And obviously embarrassed because the pro se litigant Lane Myers was handling Matthew Walker in open court. And it obviously bruised his ego. So much so that after this hearing, DA Matthew Walker removed himself from this case and then proceeded to file a motion to have Lane found mentally incompetent from representing himself. I want you to think about that for a minute. For all intents and purposes, Lane had just beat Matthew Walker in open court. So if Lane's mentally incompetent, what does that make Matt?
Objections and concerns about how he's handling his witness list.
Yep. And that's why I'm going to his neighbors with a Trump sign and asking them if they want to vote for Trump. And that's why I'm calling his wife names, because she works at the school, which is my right. She's a public. If you take your paycheck from the public, then I can call your wife, I can email her. Now I can't talk about the case, which I didn't. I said I asked her if I could come down there and get a special help
What's happening
with
his wife is irrelevant to this matter.
That's what I thought too.
If on God, if any witness other than the victim has issues with him, they have the right to file for an injunction.
So you'll not be modifying the conditions of release, Your Honor, to
At
be
this
clear?
point in time, just
Yeah.
be careful, Mr. Myers.
I know. Hey, trust me, that's my middle name.
Okay.
Walk the line. Lane, walk the line, Myers.
Matt, you're a sore loser, you're a shitty lawyer, and fuck you and fuck sickos.
And it was right after this hearing, Shannon Walker, Matthew's wife, went and got the injunction for harassment against Lane. Oh, but there's more. The next hearing is the new prosecutor going against Lane in the O'Reilly's case. And she does not do any better.
He denied the motion for incompetence like a man of honor. Thank you, sir. We can all see what's going on, and they said they didn't want to argue it. Think about it, they filed the motion, you already denied it, so, I mean, how much do you believe in a 47-page motion that you come to court for oral arguments and don't even make a statement on it? You know you're committing misconduct. You don't make excuses for him, sir. We can move on.
Judge, the state did not request oral argument on the Rule 11. The state submitted...
Because you knew it was nothing more to waste time and make me file motions in response.
So obviously by this point, I think it's pretty clear that the prosecution is just playing games. They can see that Lane means business and he's not coming here to take a deal, which is what 99% of people do. So going back to the Rule 11 that the prosecution filed during this case was to have Lane found mentally incompetent, which I think it's pretty obvious to everyone that Lane can represent himself in court just fine. This was just another dirty tactic by the prosecution to drag their feet and make Lane file more motions and go to more court dates. When it came time for the prosecution to argue that Rule 11 in open court, they had zero to say. The prosecutor in this case refused to argue her own motion. She obviously knew it was bullshit. Thankfully, Judge Riojas saw right through it and denied the motion.
Is this an objection? Then state objection. State objection.
Your Honor, the state is concerned that facts will be adduced at this moment in life, and I don't want him to incriminate himself.
I'm not worried about all that. I'm perfectly, thank you. Thanks for the free legal advice. Sit back down. And now, you should take your own legal advice and dismiss this case if you're worried. And so back to what I was saying, on my way home from getting the injunction, I drove past the university. You've issued injunctions in your 25 years. If you say you can't be within, so I drove past the university on my way home from Superior Court on Speedway. That was on Friday the 18th. So I come to your court date on the 22nd. I walk in here and there's the SWAT teams waiting to arrest me for violating the injunction for driving past the building 115 feet away. So we couldn't have court last week because I drove past the law building 115 feet away in my car, never stopped moving, never got out of my car. And that's why the U of A arrested me.
One thing we didn't mention was that before this hearing, Lane was set to depose that cop, Officer Deloria, as ordered by Judge Riojas. But when you know it, that deposition never happened. Because when Lane was walking into the deposition, he was arrested for violating the injunction for harassment against Matt Walker's wife, Shannon. And what did Lane do to violate that injunction? He drove by the University of Arizona Law Building on the way to court. Lane was driving on a public road. He never parked or got out of his car. He never so much as even spoke to anybody. And the best part is, Lane was filming when he drove past the building. And this was enough to get Lane arrested. But obviously, this was to keep Lane from deposing Officer Deloria.
They're claiming, oh, we had nothing to do with it, when literally it involves the prosecutor's wife. And they went and got that because you wouldn't do it. You wouldn't issue the order. So they went and got Superior Court to get an injunction harassment and then said I violated it by driving past the building. Well, I drove past the building on the way here. Why aren't they here? You get what I'm saying? I drove past the building on the way to this hearing. So I'm expecting them to show up and arrest me in any minute. Do you get what I'm saying? It's hypocrisy. I can't drive down the road. And then now my evidentiary hearing, we're almost at 180 days. Look what it took me to get that evidentiary hearing. And so if this is not an evidentiary hearing, I'm filing a motion to dismiss, Rule 15 motion for sanctions. All their witnesses are going to be excluded. They missed 4 witness deadlines, sir. The one by under 15 by rule. They had to turn over their witness list by rule by the first pretrial, July 11th. They didn't. Also, I filed the disclosure request. So by 30 days from that, I filed that on June 9th. So they had till July 9th. So basically, they had to the first July 11th pretrial to provide me the witness list. They did not. My record reflects like a high-paid attorney. Every motion was filed on time. It was making the right valid legal arguments. It includes case law. It includes procedure. They've got nothing on the record, but he's mentally ill. How does that show I'm incompetent? I've been doing nothing but valid. How can an incompetent person stand up here and quote case law from the Arizona court, model rules of professional conduct from the Bar Association that I'm not even a member of. I'm not even required to know them, but I know them because I filed complaints on her. And so, how case law, procedural. She's literally got her dusty ass law book, and I'm reciting it off the top of my head, and I'm supposed to be incompetent. I don't even got my phone in my hand, nothing. I literally have, everything I just said to you though is right here. Like I literally have all my arguments right here, see? I come prepared. You notice I don't have a law book? I have arguments specific to my case that include case law from Westlaw and arguments. And all this is gonna be in the Rule 15 motion that gets filed today because the sanctions are gonna be all their witnesses are gone. And if you have no witnesses, you have no case. And so, you know, if the glove don't fit, you know what I'm saying? And so here we go now, we're at your hearing when we met, sir, at the last hearing, and I'm sitting there pounding the table saying, I need you to order them to release these witnesses because now this is the 4th time I'm having them, the witness list ordered to be released. The most basic concept of a criminal prosecution, the witness list. And then, so you ordered it, right? They gave it to me that day by the end of the day, and guess what they gave me? They gave me a list containing the arresting officers and the 2 victims. They could have gave me that 4 or 5 months ago. And that's the point, sir. It wasn't like they were doing this deep dive investigation, still trying to see was there witnesses that we haven't got a hold of. You know the game. They literally, this is so boilerplate, feet dragging obstructionism, that's all this is, to gain a tactical advantage. They waited 4 months to give me the witness list after I had to literally basically get myself in contempt to prove a point that I've been telling them to put the witness, and you know what they responded by? Filing a motion saying I'm mentally ill. Not saying we made mistakes in this case. We didn't follow the rules of procedure. No, this guy's incompetent. And what they're really saying, sir, is you're incompetent because they're saying you agreed with me. So if I'm incompetent, you must be incompetent, and you ordered this, and I was pounding the table saying, I need you to give an evidentiary hearing. I need you to order the witnesses. And they're saying, well, that guy's incompetent. He was in there, but somehow the judge ordered the things I was asking for, but I'm mentally ill and incompetent. While I'm sitting here saying, you got a law degree, you've been here 30 years, what's your excuse? You were supposed to turn over the disclosure, Rule 15 disclosure, by the first pretrial, and I filed a motion to compel and all this, and you want to sit over there all high and mighty. You haven't done a single thing by the book in this case. And the first day I talked to this woman, it's come full circle. She told me she's not worried. She has absolute immunity. They don't like my legal strategy. So it's not that he's mentally ill and it's incompetent. We just don't agree with how he defends this case, because normally we go sit in a room and offer each other plea bargains, and the person acts scared, and they're like, hey man, what can I do? And they're not used to somebody who's in it, because the system, sir, we know, the system's not set up for somebody who's innocent to defend themselves, because you're not supposed to be defending yourself if you're innocent, which is why she's gonna be under misconduct suspension, because there's no probable cause. MRPC 3.8, oh wait, can I start quoting case law and all that? Will that make me look incompetent or mentally ill? Okay, so the MRPC 3.8, I'm not even in the bar. Model rules of professional conduct. You two are in the bar, I'm not. 3.8, special responsibilities of a prosecutor. First one, not move forward with a case that lacks probable cause. First rule of Arizona rules of conduct for prosecutors, this is misconduct. If you violate rule 3.8, move forward without probable cause, you're in violation of the Arizona rules of conduct. So that's literally a misconduct complaint already with the bar. And so you want to go over the rule 11, their argument is they don't like me and they don't like how I'm going about this, but even in their own motion, no less than 3 times they say, I realize I just made 3 pages of arguments and they have nothing to do with him being incompetent, but could you please pretend they were? And then at the bottom, they got really desperate and started saying, it was basically to see if you're incompetent, sir, saying, well, then he came to court and you allowed him to talk like that and make those arguments. And so I should be declared incompetent and have my 180 days that I've been banging the table for. That now we could see if they were sitting here saying, yep, we met our disclosure deadline, we turned it in by the first pretrial, we filed this, we're sitting here over here on our high horse going, look, man, we met every deadline, you're over here, you haven't turned in anything, you haven't met any disclosure, you haven't had to order me to do anything. It's been them. So how is the incompetent moron mental ill? And it's not even, I don't even like saying that because it's not even something to joke about, because like there are people, this is supposed to be a serious thing, this mentally ill and mentally incompetent. This is not supposed to be a legal tactic, a trick that you try to play to end the 180 days and then put the case in limbo, and now we can just wait a while and then disappear the case and dismiss it without, no. The argument for mentally ill should have been made months ago. They didn't make it after the first hearing, second hearing, third hearing. They didn't say I was mentally ill until you granted my shit. We've been here an hour and she didn't offer a single argument for the record why they felt they were allowed to violate Rule 15 and not give the disclosure as required by the law. She wants you to, she's got the fucking law book right there, literally, Rule 15.1, look it up. Unless they tore that page out and threw it away when they were doing Matt's disclosure to a sword. They literally, their prosecutor that has been doing the most of this case has a video on the APAC about how to do this to people, and I caught him doing it, and I used his own strategy against him, and here we are.
All right. Further, what I'm saying is December 10th, 9 o'clock is your trial date.
Allegedly.
It's been said. We'll cross that bridge if and when we have to cross it.
So
If you don't show up, I expect to notify you. If you don't show up, the trial can be held without you and a warrant issued arrest, just so that you realize if you're not here, stuff can happen. Okay?
So is there a trial acknowledgement that can be served on him without him having to sign it?
Yes.
And can the state get a copy of that, Your Honor?
it's not gonna save you, Mary.
Thank you very, very much.
The trial acknowledgement is not your smoking gun. It's not your magic piece of evidence, the trial acknowledgement. This case doesn't hinge on the trial acknowledgement. And if you want to talk about trial acknowledgement, I'll show you one that said I acknowledged the trial for September 30th. And I'll show you the same minute entry that said you had till August 9th to turn over your disclosure list, and you didn't. So before you worry about trial, you better worry about arguing how you're going to get these witnesses up on that stand and get them past the Rule 15 standard, because as soon as, if he doesn't grant it, I'm filing a special action. Immediately. Writ of mandamus, straight over to Court of Appeals, and I can guarantee you this case won't go to trial, and you'll be sanctioned, and you'll be under prosecution just like April and the Maricopa County. You know what you're doing. You're violating MRPC 3.81. Special duties of a prosecutor. You cannot prosecute without probable cause.
I want you to remember what Lane just said, that this case is never going to go to trial. He knows this. The prosecution knows this, but all they're trying to do at this point is save face. The prosecutors are just trying to make this whole process as painful as possible for Lane, knowing that they have nothing. This next hearing is Lane going in front of Judge Alexander Ball. This hearing is for Lane violating the injunction for harassment against Shannon Walker for driving past the law building. And just so you don't get confused, the prosecutor in this case is Samantha Walker. No relation to Matthew Walker or his wife Shannon, the one who filed the injunction to begin with.
I'm putting myself in timeout so I don't keep cussing at you, because this is turning into a kangaroo court, and I had more respect for you before I walked in here. They're seeking jail time because I booed at City Hall, not because of this. This is a mockery, sir.
Jail time on that case.
Huh?
I'm not seeking jail time on that case. Please don't mistake the facts.
No, you're seeking it in this case to get it out of that, to try to cover up what you're doing in that case. You're a clown, plain and simple. Are we done here? Sir, you want motion to compels? Because I know judges hate motion to compels. Because I'm gonna file one every day. Where's the disclosure? It's been so.
Again, Mr. Myers, you've asked a litany of questions here.
I gotta talk fast before I get arrested.
So if this wasn't enough already, another layer to this case is Lane was arrested in June of 2024 for booing at a Tucson City Hall meeting.
Boo! Boo! Boo!
Those booing, we're gonna have to ask to remove you if you continue that.
Boo!
Alrighty, we're going to have to ask to remove you, sir, if you continue to interrupt.
If they can clap, I can boo. It's that simple.
So the last one is a surprise one, and I want to invite my colleagues on the council to join me up here. And I'd like to invite the city manager to come up here.
Sir,
Don't touch me.
you need to go outside.
No, I don't.
You will be going outside.
Are you gonna remove me?
Yes.
I dare you.
Ben? The mayor, sir?
The mayor did not ask me to leave.
Yes, she did.
Don't touch me. Back up.
Go that way, please.
I'm going that way.
No, you're going that way, because that's the exit.
I'm gonna actually sit right here.
No, you're not. You're going to go. Sir? Sir, you've been asked to leave by the mayor.
No, I haven't.
Yes, you were.
Hey, city attorney, if they can clap, I can boo. Get your mind right.
The mayor asked you to
The mayor don't have that authority.
Yes, she does.
No, she doesn't.
Yes, she does.
You have one chance.
Thank you.
Get up and leave.
Go.
Or what?
I'm gonna arrest you for trespassing. Let's go.
You're gonna arrest me for trespassing?
Yes.
Then do it. Let's go. Come outside and give me the ticket. Let's go. Come out and give me the ticket. Rankin, you'll see the lawsuit tomorrow with. Don't touch me. Do not touch me. I am voluntarily leaving. Do not fucking put your hands on me for any reason. I am leaving like you asked me. Don't fucking touch me ever again.
Good. Bye, sir.
Thank you. Come here, Williams.
Alrighty, so this is.
Get it out.
The last meeting.
I'm not giving you my ID. Arrest me.
Okay.
Arrest me right now.
Are you gonna give me your ID?
No.
I need your identification.
Arrest me
What's your
right
name,
now
man?
for trespassing.
All right.
Thank you.
There you go.
Perfect.
There you go. There you go.
So they had the Tucson City Police remove Lane from the meeting, which they then proceeded to arrest Lane once he was outside. So fast forward a little bit, the charge in the booing case was later dropped. Now Lane obviously has a lawsuit there because they arrested him for free speech. And Lane has made it very clear that he intends to pursue that lawsuit. And this is just another reason why the city of Tucson and Pima County are collectively coming down so hard on Lane right now. He's made them look bad in open court multiple times and he intends to sue them. But we're still not done yet, folks.
So again, that would.
I drove past the. Will I be arrested on my way out because I drove past 30 feet past the law school down Speedway today? We need to get to the constitutional issue of these charges. We can't even arraign me without probable cause.
Your Honor, I would implore you to.
I would implore her to not interrupt.
Again,
Is she objecting or is she talking over me?
Yeah, so we can't have people talking over each other because we are recording.
It's my
everything.
turn to talk.
Right, and so then Mr.
So I drove past 30 feet on the way there and I'm gonna drive past 60 feet on the way home. Will I be charged, yes or no?
So, Mr. Myers.
I'm charged with being 150 feet from a protected location in a moving vehicle. So will I be charged on the way home because I drove past on the way here and home? I'm gonna drive past the same location that you're arraigning me for and make a mockery of this whole fucking thing.
Mr. Myers has historically recorded without permission, as well as broadcast information without the court's permission.
Objection, Your Honor, irrelevant. I got permission. This is the gaslighting that they want me to get me pissed off and arrested at for today.
So, Mr. Myers.
She doesn't even know the rule. 122H,
Mr. Myers.
broadcast is not coverage.
Right, again, Mr. Myers.
Just tell her to be quiet then.
We'll maintain decorum, again.
I just dealt with this yesterday with the same thing in a different hearing yesterday with this bullshit with her.
Your Honor, at this point, I would ask that you hold Mr. Lane Myers in contempt in order
Myers.
to obey the court's orders.
Again, I'm going to remind you, we're not to use profanity here in the courtroom.
Actually, it's my First Amendment right to use profanity.
Why is it that at every hearing, Lane has to fight with Tucson City and Pima County courts for the right to record his hearing under their rules? If you watch any of Lane's hearings, this comes up at every single one of them. What is it that they're so scared of people seeing? You would think that they would want transparency, right? But at every single hearing, Lane has to fight to the point of almost being arrested.
A person who wishes to record or broadcast the audio portion of a proceeding with a device.
That is not on the person. That is not on the person. That means setting up my fucking thing over here in the corner or blocking. You can't be obtrusive. You can't have cords all fucking, they're all tripping over.
Again with the profanity.
But I'm saying, you're gaslighting us. The hearing's already over. I already recorded it. It's already been broad streamed, and so have hundreds of other people. It's not going to stop.
I'm attempting to read the rule.
I don't need to know the rule. I know the rule. That's why I came in here, notified her, and I'm following it. It's on my person.
Right, again, Mr. Myers, it seems like I'm not reading the rule for your benefit, but again, for the record, as well as for Ms. Walker.
Thank you.
And so, can we
Thank
please
you.
not interrupt
Thank
the
you.
court?
Thank you.
But a person who wishes to record or broadcast the audio portion of a proceeding with a device that is not on the person must do so. Of course, now at this point, Mr. Myers, I don't see the device on your person.
I'm putting myself in timeout so I don't keep cussing at you, because this is turning into a kangaroo court, and I had more respect for you before I walked in here.
Right, and so, Mr. Myers, I don't know why you think it's a kangaroo court.
I'm saying it's not. I don't want it to be.
Right.
Because we're arguing over something that, why do I keep having to come in these hearings and tell them how the Supreme Court rule works? What is she afraid of?
Mr. Myers, this is
the truth?
Mr. Myers, this is the first court hearing in this proceeding. I don't know what.
But she's bringing it, she's talking about other cases, saying it's a big media case. Well, maybe you shouldn't have arrested me for booing at the city council meeting and it wouldn't be a big media.
Again, Mr. Myers, I don't know what's going on in your other legal proceedings.
Well, she wants you to know. She wants you to know that all this attention is because I'm making videos about her because of other cases. Now I got all these people that want to know what's happening to me, and now they're making videos of her, making fun of her, and I put her picture on a t-shirt making fun of her, and so now she doesn't think that 122H should apply to me.
Mr. Myers, I'm not aware of any of those facts. And again,
Oh, I'm sure she's going to follow that motion like she did in the other case. I'm sure you're going to get a Rule 11. I'm sure you're going to get all that. I'm going to follow Rule 11 on her, actually.
Mr. Myers, that would be not, again, a legally non-cognizable filing.
This whole proceeding is a joke to me.
Your Honor, I think at this point.
Because what happens when the injunction gets thrown out? Because I'm appealing the injunction. So if the injunction gets thrown out, how did I violate it?
It was held out yesterday.
That's irrelevant. See, she just brought that in there. That's prejudicial to the proceedings. That needs to be stricken from the record.
This next hearing is another injunction for harassment filed against Lane by one of Shannon Walker's coworkers, Stacy Jane. Lane had reached out to Stacy twice asking for help, all in relation to the booing case with the city of Tucson. And she would end up twisting Lane's words to make it sound like he was threatening in those phone calls.
So put her under oath, and she needs to testify to what's on the petition and nothing else.
She's under oath.
Okay, because you let her make protective order statements talking about things that are not on this petition. Okay, and if you want to talk about things that are on this petition, you got to give me a chance to either adjourn the hearing or take time to go over her new statement. She needs to amend the complaint if she wants to talk about things that are on the not in this petition. And you just allowed her, under the protective order thing, to make allegations that are not in this petition, and you did not strike them from the record.
Okay, thank you.
I'd also like to ask that not only that the protective order be enforced, but that it also prohibit Mr. Myers in the future from having any direct or indirect contact with me in the form of social media, that he be prohibited from posting or putting my contact information, including my work contact information.
She's an employee of the state, sir. You cannot allow this.
And that to not through social media or otherwise directly or indirectly encourage third parties to contact me or go to protected locations.
I can guarantee you that I'm going to keep those videos up and make more. And there's nothing you or her will do about it. She's an employee of the state of Arizona. Is she done? Is that because she hasn't testified to anything in this petition or presented evidence of these allegations of harassment? We have to get through this. Her opening. I just went through this last week. She needs to give her opening statement, and we need to enter the evidence in.
Do you have an opening statement?
As soon as she enters her evidence in.
Okay, you're reserving your right.
Sir, she needs to.
Don't tell me how to run the court.
I've been through these.
Good. I'm glad you have. I'm just asking, are you waiting your right to give an opening statement, or are you reserving it until later?
No, I'm gonna give it right now.
Okay.
Put me under oath.
Well, okay. You swear for my testimony you'll be whole truth, nothing but the truth?
Yes, sir. Under the penalty of perjury. Make sure you say that to the next witness, or the next case too.
That's okay.
It is under the penalty of perjury, right?
Well, there are laws concerning perjury.
All right, because that oath means something, right?
It does.
Okay. So she claimed no legitimate purpose. Okay. She is an employee of the state. Second of all, there was clearly a legitimate purpose. First, so when are we going to discuss this? Because my opening statement shouldn't be about what's in the petition.
Okay. You want me to have her testify?
Well, that's what I'm saying is like my opening statement is going to be, are we just here to saying I'm here to contest this? Because I'm here to contest this because first of all, there was,
that's what it is.
she put an incident on here that was from 2.5 years ago. So automatically, and this woman, let's make some judicial notice of adjudicative facts. She's an attorney, an Arizona member of the bar, and was a law clerk for 13 years at the federal court. She knows how to read a legal document, and where it says no items outside of 1 year, she put something for 2.5 years to taint, prejudice this, okay? Why would somebody with a law degree who spent a career reading legal documents put something that wasn't allowed to be put on this document if it wasn't willfully and knowingly an attempt to prejudice the person getting this hearing? You cannot put something, it's all within 1 year. 2.5 years ago, an email where she said thank you and have a nice day at the end of it. First of all, I had a legitimate purpose to contact her, and we're going to hammer that home today.
Are you testifying or are you making an opening statement?
Both. I'm making my opening statement.
Okay.
Because I'm here to contest this under LaFaro, Cahill and LaFaro and all this. First of all, she needs to prove 2 or more contacts within a year. So putting something 2.5 years ago, that's already written off. Okay. So then the next one you need to prove. She even stated herself, legitimate purpose. She's an employee of the state of Arizona, and the electronic harassment makes it very clear, which subsection C states, constitutionally protected speech or activity or to any other activity authorized by law. So if she's if she's a state employee, I have a legitimate reason to call her and redress grievances. However, I have a legitimate purpose beyond just the default redress grievances with a public employee. I called her asking her specifically a question about her she started this program, Access to Justice, right? So I had some legal matters taking place in the county, and I called her up and asked her if she had any help for me about at the instituted whatever Innovations for Justice or Justice for Steps to Justice or whatever these programs that she creates to make it seem like she is helping people in the community, where I call up there and I say, hey, Stacy, I mean, so are we I feel like she should need to testify before we, so my opening statement is, I believe these were, first point of order, she put something on there that wasn't allowed to be on there, willfully, knowingly, and intentionally in an attempt to prejudice this. Second of all, the two legitimate two contacts on there that we can talk about on the petition that were within a 1-year time period, I believe are legitimate whether she was a state employee or not. So let's let her let's let her testify to these contacts, and then I'll dispute them.
How do we do that?
Can I ask a question for clarification?
Sure.
Is the burden on me to justify the protective order should remain in place?
Absolutely.
The burden on
The burden of
Mr.
proof is
Myers?
on you.
Unfortunately for Stacy Jane in this case, she didn't realize the burden of proof was on her. And remember, she is a bar card carrying lawyer and a professor at the law school, going up against Lane, who doesn't have a bar card. Now, if you go and listen to this full hearing, which is on our channel, it's pretty clear that Stacy's in way over her head and that she should never have tried to bring this injunction for harassment.
It's on you.
Absolutely. You need to prove these allegations
I can answer that question.
beyond a reasonable doubt.
No, it's not.
Well, if she doesn't want to get hit with a lawsuit, she's going to have to prove them beyond a reasonable doubt.
Well, that's irrelevant.
Abuse of process, malicious prosecution, all that. Yes, she's a lawyer and doesn't even know the burden of proof's on her. She probably didn't think this through very well.
Do you really need to make that comment?
This is deep.
I guess it is.
I guess we're not allowed to talk about what this all involves, though, because she doesn't want to talk about what happened and why I called her. But we're going to talk about it now, so I don't know how she can avoid it.
Oh, she can avoid it if you won't let me ask her.
Okay.
The burden of proof is on you.
Your Honor, I don't consider Mr. Lane's communication to me on December 2022.
2022, Your Honor, 1 year.
Okay, you can object to it. I'm going to hear from her first.
That's you cannot allow her to make statements that are not within the 1 year period. You can't. We don't have time. You're talking about we might not have the next hearing. You can't let her babble on about things that are irrelevant. And I don't need to be sitting here interrupting you. If it isn't in 1 year. This petition was signed on 10 what is because it's kind of scribbled 10/9, 10/7. What is the date? 10. The hand.
What's the relevance?
It was on 10.
Sir, I'm addressing your issue, sir. What is the relevance of it?
I am trying to move through my contact.
10/7.
Mr. Myers.
You don't get to talk about contacts that are not within 1 year. 10/7. Run this.
I have your objection. Objection overruled. Go ahead just briefly for context.
For context, no. Continue this hearing, sir.
Why?
You're not going to give me a fair trial. You cannot there's no context to an act that took place outside of 1 year. It's prejudicial to my case. It's hearsay at this point, and it's irrelevant. She's not admitting hearsay in an injunction harassment there's no legal standard to talk about something that happened outside the 1 year period in an injunction for harassment, sir. We can turn this into a kangaroo show, or you can enforce the rules like every other judge in this county. You cannot talk about something for context. So I get to talk about anything I want then, for context. I get to talk about how I think she got my wife fired for calling Judge Zips.
Now, one thing we haven't brought up yet is Lane's wife was a law clerk for a federal judge across the street, Judge Zips. Now, it's important to note that after Lane made one of these phone calls to Stacy Jane for help in the booing case, Lane's wife lost her job. And Lane's wife had nothing to do with any of his cases. But just hours after Lane made one of these 2 phone calls to Stacy Jane, his wife was forced to resign from her job, a job that she had worked to obtain for her entire life, being the lawyer for a federal judge. You can't help but really feel for Lane's wife in this case. She's an innocent person who lost her dream job for doing absolutely nothing.
Context, right? It's context, right? No.
All right.
It's fucking irrelevant. It doesn't matter if I contacted her 100 times before then. Thank you. I won't cuss again, but you can't just allow this thing to spiral out of control. There's rules to this stuff, man.
Now, well, why don't you try obeying something?
Who's going to hold you in check?
Well, I guess you can appeal.
That's all you care about, right? Oh, I guess you can appeal. My rights don't matter to you?
Yes, they do. Go ahead.
There is no legal grounds for you to issue a continuance halfway through the hearing because the plaintiff didn't get her way. That is absolutely not what happens in these hearings at any point in any time, and it will not happen to Lane Myers.
Having listened to the October 12th call on
September 12th.
Excuse me, September 12th call on a couple of occasions, even listening to the tone and listening to the subtext, I just cannot find that constitutes an act of harassment. It may be that the other acts that you talked about that were not included within your petition may in fact constitute acts of harassment, but the law is clear, and it's got to be done before the hearing, that if you want to amend to include other acts, You could do that, but that was not done. Because of that, I'm going to have to dismiss this order. I guess somewhat reluctantly, because obviously...
Don't say that, sir, on the record. You can't say reluctantly. You sound like you're lawyering for her.
I can say I am reluctant, but I'm going to dismiss the matter.
That's prejudicial to me, though.
Okay.
Saying reluctant. I get it, though. Thank you, sir. Appreciate it. I'll be...
Quit interrupting me.
I know. I
know you know that, but you continue to do it.
I don't even know how to be quiet when I'm winning.
And even though the judge clearly didn't want to rule in Lane's favor, he had no choice but to, based on the facts that Stacy Jane herself presented in this case. Make sure you go and listen to this hearing. It gets pretty intense. The judge, he's not happy.
This next hearing is on the same day in front of the same judge. And it's another injunction for harassment hearing against Lane. This injunction for harassment was filed by the lying cashier in the O'Reilly's case, Mackenzie O'Brien. Now, if you want to listen to a hearing that's going to make your blood boil, this would be the hearing to listen to. Mackenzie does nothing but lie under oath for this entire hearing. And Lane brings the receipts with both video and audio recordings to prove her lies. At points, this hearing gets way out of hand.
You told me not to interrupt. I didn't want to make note that she got fired for these allegations.
She didn't get fired, Your Honor.
Why is that woman in the back
Wait a
talking?
minute, hold on.
Is her mom holding her hand now or what?
You guys, you're over there running your
Hey!
him. Listen, wait, time out. He can
No!
his people, but
That's Mackenzie's mom getting yelled at by the judge.
You, I need both.
I'm gonna get the officer.
Oh, you're not getting it. Come on back here and sit down.
I mean, this is not. No,
That just- let me
we've
take
had
it.
previous with her mom.
Okay. The one, no interruptions, okay?
You're right, you're right, you're right.
I mean, it doesn't serve any purpose. It doesn't help her.
Apple doesn't fall far from the tree either, sir.
Strike.
You see where she got it from, right?
What did he say on July 11th outside the courtroom that you essentially found to be harassing?
It wasn't necessarily what he said, it was the fact that he followed me around the upstairs in the courtroom and followed my mom around and proceeded to scream at my mom for her saying that I can't talk to him.
And how close was he to you?
Pretty close.
I'm gonna ask that, Mr. Myers, do you have this on video?
Absolutely.
So,
This is the biggest. That should be first degree felony perjury.
okay, you quit commenting on the evidence.
We're gonna put that.
You got one?
We're about to play a tape that right there was a complete fairy tale.
Okay, well, I'll look the tape. I just asked you if you have the tape.
Of course I do. She didn't know I was recording, and this is what happens when you lie, you get caught. Your Honor, I would move the court to force her to enter that in evidence.
Oh, do you have it?
I don't have her 11-minute video. I have the clip that she presented to the police as evidence, which she only turned. So she just admitted here in court. She has an 11-minute video, but when she filed the police report on me, she only turned over 18 seconds. So the police, she told the prosecutors in my case, she only has the 17 seconds. I have motions to compel from Judge Klotz, compelling her to release the whole video, saying she doesn't have it, and now she comes here today and admits she has it. No. You're going to dismiss this right now.
I'm not dismissing it.
You need to do the right thing, sir. There's no continuance. There's no continuance. There's no continuance. This is not being continued in the interest of justice. The evidence is overwhelming. She's been charged by the Pima County Attorney Office for perjury for these same... There's the case number.
Okay, but when?
Okay.
Where's the officer that came to me?
Oh, they'll be coming. Trust me. They might be waiting for you outside. Let her talk, sir.
All right.
Let her make up any lies she can come up with. This is her last chance to come up with the best lies she can come up with.
All right, we got to continue the hearing.
What do you mean?
It's time's out.
Well, then you need to make a ruling.
I don't have to make a rule.
So what are we going to do? Go over the same evidence again? She has not met the burden of proof, Your Honor. She claimed that I followed her around. She said there's a part missing. I have the entire call, and I only pressed pause because of time. We could keep the call going for the next 18 minutes where she claims that I did something.
Quit yelling at me! Having listened to the testimony, it seems clear to me, one, that the incident of May 20th does not constitute harassment against Ms. O'Brien, possibly against the other guy, I don't know, because he's not here, but it doesn't count. And the second one, in terms of this July 11th one, possibly harassment of the mother, but not of the defendant or the plaintiff. Therefore, I'm going to dismiss the case.
Thank you.
In the end, it's clear that she is a liar, and her injunction was also dismissed. Lane went 2 for 2 that day.
Man, that was wild. I can guarantee you that judge is going to need to take about a week off to recover. I actually feel bad. The judge was so old, and he was losing his shit.
So this next hearing is Lane going back in front of Judge Ball for the violation of the injunction for harassment against Shannon Walker. And it doesn't go well for Lane. Remember, we brought up that Lane has to fight to be able to record his own hearings, even though by law he's allowed to. At this hearing, Judge Ball refused to allow Lane to video record the hearing and also didn't allow other participants to join on the Zoom. This created an argument between Judge Ball and Lane was ultimately held in contempt, arrested, and put in jail, all over recording.
Are we having a hearing today or letting you talk all day? Because I got a hearing at 10. I have another hearing at 10. You're wasting my time. This isn't your world. This is your courtroom. Where's the Zoom? Why can't my family Why can't my family be on Zoom right now?
What the rules are.
There's no rule that my family can't attend on Zoom. Keep going. Let's go.
Keep interrupting. I'm going to hold you in direct contempt of court.
You don't scare me, bro. Let's do the hearing.
All right, I'm holding you in direct contempt of court this time. If you could take him into custody.
But then after all was said and done and Lane spent the night in jail, Judge Ball walks it back and said he never said to take Lane to jail, even though it's all audio recorded. Judge Ball placed the blame on the officer who arrested Lane. If you listen to one of Lane's follow-up recordings, once he got to jail, they had no idea on what to book him on. So once at the jail, they literally had to put a false charge in the computer to book Lane, but he was ultimately released the next day with no charges.
I went to jail last night because I hurt Shannon Walker's feelings yesterday. I spent the night in jail last night because let's put this together. So I made one call to Shannon Walker and left a voicemail. Other people called and left voicemails, not me. I made a couple of YouTube videos about a public employee. They got an injunction for harassment somehow. And then I violated that injunction for harassment by doing a U-turn and got arrested at court. So I don't feel safe. I come to court. I get arrested. They're willing to arrest me to avoid due process. And then I get arrested. So then I'm in court yesterday because I was in there the whole reason we had a court date was because I did a U-turn after leaving one voicemail and making some YouTube videos. So I made a YouTube video. Two YouTube videos, and I left the voicemail. That wasn't the voicemail itself was not a crime in and of itself. Like there was nothing contained in the voicemail that was like that's a charge. It was just like, well, if you felt, and so I left one voicemail, made some YouTube videos about public information. She gets an injunction. They arrest me to stop the court date with Deloria. Then they charge me with fucking contempt and take me to jail overnight. So I've been to jail 2 times because Shannon Walker got a voicemail and some YouTube videos.
So in the end, all the cases they were trying to bring against Lane were dropped. The booing case, the O'Reilly's case, and several other cases we didn't even bring up. All dismissed. Now, obviously, this didn't sit well with the Walkers, Tucson City, or Pima County. They wanted Lane to stop making videos on his YouTube channel. And some would say they wanted retribution for Lane making them look silly in open court by repeatedly out-arguing them at every hearing. So then this happened.
Your Honor, the state is asking for a $25,000 bond and pretrial services release if that is posted. We're also asking for numerous conditions of any release. As far as the non-monetary conditions, we are asking for him to not possess any firearms. In the most recently, he talked about wanting to get a firearm. Given the safety risk in this case, we are concerned if he were to get a firearm. We're asking again for the no contact with the victim. We're asking for no contact with the victim's family, including no contact through any third party. We're asking for him not to be able to access the internet. He has been actively using the internet as a way to harm this victim, to harm other people, to intimidate any potential witnesses, to intimidate judges, to intimidate prosecutors. He has been posting, asking for people to go to people's homes and to go to their workplaces and to reach out to them. So I believe any further access he has to the internet will put people at harm. He can go, even if he represents himself, to the law library and be able to access what he needs to be able to do legal research. We would ask, if the court's not willing to just do no access to the internet, that he not be allowed on social media or to request third parties to post anything on social media regarding this case.
Pima County got together and they came for Lane. They brought 14 new charges against Lane, 8 felonies and 6 misdemeanors, all for violating the injunction for harassment against Shannon Walker. Remember, she's the wife of the district attorney in the first hearing that we showed you, the district attorney that Lane exposed for being unethical in the case. Most of these charges are related to videos made on YouTube and memes. Yes, you heard that right. Memes. In some of these videos, other creators make. Lane had nothing to do with it. So Lane went to court facing these 14 new charges and was given bond. And they wanted Lane to take down all of his videos, even though it's constitutionally protected speech about a public official. But it gets better. And by better, I mean exponentially worse.
The new charges are they're not before me.
They're going to arrest me when I walk out.
It's not before me.
But then I'm going to go to jail and I won't be able to talk to you.
I was hoping it was already filed, like some sort of indictment. That wasn't the case. That's why I brought it up. Unfortunately, it's not yet filed, which means you have to go through the process, which I believe I told you, about 10 days.
My car's sitting out there.
Okay. We're here on
Why can't you be respectful and professional?
I'm trying to be.
No, not me and you. These over.
We're not talking about that.
We are though, because you know that as soon as I walk over here, and then I'm like, how am I going to be able to respond? If you say, if you need further briefing in the slap or something, and I can't do it, then I'm screwed.
No, it doesn't work that way. If you're in custody and can't respond, we'll give you additional time. But it won't work that way. I'm not going to. No, it doesn't work that way. You're not going to be prejudiced in this case because you've been arrested on new charges. Okay?
Yeah, they're going to say that I committed a felony while I'm felony for a bond.
That's different.
For making a meme.
That's different. That's different than your slap motion. All right.
Well, I'm going to put a new one on the next one.
Okay, you can do that if there's new charges filed. That's not what we're here for today. Let's
well,
really.
I'm scared that if I give up my right now, I won't be able to have it in the next case.
Have you right to rep attorney?
Yeah.
No, it's a separate case. I accept it. I'll accept the appointment on the new.
So you get a new attorney in the new case, and then you can waive your right to that attorney, and you can file a slap motion in that case.
So there'll be CR over here, CR over here.
Correct.
Judge whatever, judge or you maybe you.
Same
okay,
judge.
Okay, so it'll be 14 over here, whatever the new over here.
My understanding is the concern was I'm not ready to file a slap motion. I don't know if it's proper or not. It sounds like there is some merit, but I would have done it differently, and which means if I stay on this case, technically the court has to say it goes through me. That's why I'm withdrawing so that your motion will be filed.
That's what I'm trying to say.
Okay. All right. So, Mr. Myers, I can have you stand and be sworn by the clerk first. Then I'm going to ask you some questions about your waiver of right to counsel.
He just came in here and said all that and doesn't even provide any proof. Show me right now. Why am I not charged then? So if I told everybody to contact the victim on a live stream, why am I not being charged? Because it's never happened. I've never in my entire life told anybody to contact this woman at any point in my 42 years on earth, okay? So for her to come in here and say, oh, he's on the live stream, I have the right to do that. I can go on there and say, hey, friends and family, I'm doing all right. This is what happened at my last court date. This is what's going on. This is what I'm going to use for my defense. This is what the evidence is. This is all under a bar. And that's what you should have saw in my slap motion. A bar attorney, a member of the bar association could hold a press conference and say, yeah, we got these police reports, and they say, yeah, he's her ex-boyfriend, even though he's not her ex-boyfriend. And we want to make sure that we let the whole public know that at no point were they ever in a relationship, despite a police report being signed under the penalty of perjury, that it says that I'm her ex. So obviously, you signed a police report under the penalty of perjury that I'm her ex. I have the right to go on to tell the public I am not her ex. That is not a crime. But I'm being charged for making a video saying, I don't know why it says in the police report that I'm her ex. I'm not her ex. I've never even met this woman. So I absolutely, can you pull that back up? Specifically to correct the inaccuracies, I'm literally holding an email right here that says, this is from me to Matt Walker months ago. I do not condone those crazy messages in any way. I had no idea those were being left because I wasn't the one leaving them. I don't know the tone of the voicemails because I didn't leave them. I do not encourage or agree with that and would never want my wife to get those either. Talking about crimes is way past what we are doing here. I'm talking about crimes, alleged. I am going to make a video addressing anyone calling on my behalf. Better not ever do that. Or they
slow down again. All right, so we're getting far.
Lane had a court date just a couple days later because Pima County had filed even more charges relating to violating the injunction for harassment against Shannon Walker. And when Lane showed up to court, police were waiting outside of the hearing to arrest him. And that's where we're at now. Lane is currently being held without bond in the Pima County Jail, facing almost 20 charges for violating the injunction for harassment against Shannon Walker. Now, this is another dirty move by Pima County because they know holding Lane in jail won't allow him to prepare for for all these cases. So far, Lane has filed an anti-SLAPP motion, which has yet to be ruled on. But as it appears right now, Lane is going to be in jail until his trial for all these cases, which, based on Speedy trial rights, has to be within 180 days.
So as we can see, an injunction for harassment in the state of Arizona requires a series of acts over any period of time. That was a series of acts over any period of time that is directed at a specific person that will cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses the purpose. And here's the key: serves no legitimate purpose. First Amendment protected activity always serves a purpose. Because I left her one voicemail, that would fall under electronic communication. And that section does not apply to constitutionally protected speech or activity or any other activity authorized by law. So she's a public official, a public employee of a public university, with a public website, with a publicly listed phone number and email. Therefore, she's a matter of public interest. And therefore, I called and left.
You have reached Shannon Walker, Director of Special Projects at the James E. Rogers College of Law. Please leave a message and I'll call you back as soon as I have a chance. Thanks.
Hi, my name's Lane Myers, 520-771-2021. I see you're a Director of Special Projects. Well, I'd like to ask if you could approve a special project where you help me end your husband's career for being a crooked-ass cop, prosecutor, wannabe, whatever he is, hiding these cops from prosecution. I figured the U of A, maybe Stacy could help me. Maybe I should talk to you or Stacy or maybe one of these. Because, you know, my wife also is an alumni of the College of Law and is actually has taught there. So, like, we got two sides that are about to come crashing together here. So, you can help me teach your husband how to follow the law, or I'm going to take his career. So I figured, since I'm a member of the community and my wife's an alumni of the law school, that maybe I could get access to the materials at the law school in order to fight for justice, since Stacy's all about justice. So I guess I got to call Stacy next. So that was my one phone call. I made one phone call to the publicly listed number. Director of Development. She was the Director of Special Projects. But as you can see, no secret website. University of Arizona, right on the website, publicly listed. All I did was call that number right there on this public. So I called the number. So as you heard so look, case law says evidence of a single conversation between alleged harasser and alleged victim did not satisfy the series of acts. At a minimum, the series of acts condition of a statute authorizing requires two incidents: injunction against harassment, which prohibited alleged harasser from any in-person contact, was unconstitutionally overbroad because of its infringement of alleged harasser's constitutional rights to free speech. Alleged harasser was restrained from engaging in political speech in alleged harassment victim's presence. Statute authorizing injunction against harassment cannot be used to restrict protected political speech. So you can't get an injunction against First Amendment activity. But Shannon Walker, so I call this First Amendment activity. It's on the website, as we can see, the case law. So I make a call. We heard it. She decides to go to court and lie under oath and commit perjury. So
Now, we fully understand that Lane is a polarizing character, and he doesn't get along with everybody on YouTube, but I don't think anybody does. But he's always been good to us and allowed our channel to make content based on his hearings. He was actually our first viral long video that we made. If you feel like supporting Lane, check out the description in this video. We'll have all of the links there to be able to do that. Now, if you want to keep up on what's happening with Lane, a good channel to check out would be This Is a Public Service. He has all the day-to-day updates for Lane and his case, and he's a great source of information for that. Also in our description, you'll find all of Lane's charges and any of the motions that have been filed so far. Now, if you made it all the way to the end of the video, thank you so much for watching. And remember, if you would like to support Lane, make sure to check out our description for links to be able to do that.
Our channel is Dark Times with Nico and Sai, and we will see you in the next video.
Goodbye for now.